beautiful for spacious skies, for amber waves of grain, for purple mountains, majesty above the fruited plains. America, America, God shed His grace on thee, and crown thy good with brotherhood. From sea to shining sea.
Hello, everybody, and welcome. Thank you for joining us. We are the Alturas Institute, and this is Constitutional Conversations. The song that you just heard was arranged by the brilliant Steve Eaton and was sung by Idaho State Senator Cherie Buckner Webb and features 8-year-old Charlotte Laveau. So thank you so much for allowing us to use that song. We absolutely love it. And before we get started today, I just wanted to remind you all to please donate to the Alturas Institute if you can. We don't have a donate button on our video today, so if you would like to donate, we will leave that information in the comment section. You can find us on Venmo at the Alturas Institute, that's one word. And as always, you can go to our website, alturasinstitute.com, and donate there. And then we also accept checks to 428 Park Avenue, Idaho Falls, Idaho, 83402. So thank you again for joining us. And without further ado, I would like to introduce you all to Dr. David Adler, who is president of the Alturas Institute.
Thank you very much, Taylor, and greetings, everyone. We stand at a historical juncture here in American history as we take a look at the fact that we are just a little more than 3 weeks away from this next presidential election. We've witnessed a presidential debate. We've witnessed a vice presidential debate, and campaigns are in full sprint toward November 3. And one of the very interesting facets of this election season is, of course, the fact that President Trump has nominated Judge Amy Coney Barrett to the Supreme Court to fill the vacancy of Justice Ruth Bader Ginsburg. And this has plunged the United States Senate and millions of Americans into great debate about the propriety of the nomination by President Trump just 40 days from the election, and the determination of Senate Leader Mitch McConnell to push forward to drive this nomination to the finish line to secure what would be Donald Trump's third appointment to the Supreme Court. And of course, all of this is occurring in the midst of the terrible COVID pandemic, and our president has contracted the virus. Numerous senators have contracted the virus. And so there's a lot of uncertainty surrounding the pending Senate Judiciary confirmation hearings for Judge Barrett. She is something of a controversial figure, if through no fault of her own, the fact that she would succeed an iconic liberal justice, Ruth Bader Ginsburg, but she also has attracted considerable attention because of her own judicial philosophy, and the sort that she has outlined in some speeches, in some articles, and in public statements, saying that she is very much in alignment with the former Supreme Court Justice Antonin Scalia, himself an iconic conservative jurist who was well known for exalting his view of constitutional interpretation, known generally as originalism or textualism. And so if, in fact, Judge Barrett is a devotee of Justice Scalia's philosophy, questions abound because, of course, Justice Scalia was very controversial precisely because of his philosophy. So as the nation pays very, very close attention to this nomination, given the fact we're just a week away now from the beginning of the Senate Judiciary confirmation hearings, we here at Alturas thought that the timing would be very good if we took a historical look at controversial Supreme Court nominations. And that's what we intend to do in our short time together. As a review, if we were to consider just a basic constitutional primer governing the appointment process for all federal judges, but particularly for Supreme Court justices, we would note a couple of provisions in the Constitution. There is, first of all, Article 2, Section 2, which provides that the President shall nominate and, with the advice and consent of the Senate, appoint candidates to the Supreme Court. Article 3 of the Constitution attempts to provide protection for federal judges, including Supreme Court justices, by ensuring that their salaries may not be diminished during their time on the bench, and further that they shall continue to serve on the court so long as they exhibit good behavior, which for all intents and purposes means that they have avoided the commission of an impeachable offense. Indeed, historically, only one Supreme Court justice has ever been the subject of impeachment hearings, and that was Justice Samuel Chase in 1804. While he was impeached by the House of Representatives on roughly 8 charges, he was cleared of all of those charges by the United States Senate during the impeachment trial, but only by the thinnest of margins, by a single vote, because it takes 2/3 of the Senate to convict and remove a sitting Supreme Court justice. But we understand that serving while exhibiting good behavior means essentially a lifetime appointment. The age of a nominee becomes very important, and in this case, many are pointing out that Judge Barrett could well serve for 30, 35, 40 years, who knows. And so we take a historical look tonight to bring Judge Barrett's nomination into something of a historical perspective. By the way, the Constitution says nothing else about nomination credentials, qualifications for a prospective Supreme Court justice. And so it's often simply left to the judgment of any particular president to determine whom he and someday she would like to place on the bench. So let's begin by taking a quick overview historically of how the appointment process has involved some controversy. We begin with one of President George Washington's nominees, and that was John Rutledge to the position of Chief Justice. He was nominated by President Washington to fill the created vacancy of the chief position when Chief Justice John Jay decided to resign and return to New York to become governor. And so when President Washington decided to nominate John Rutledge, it was, as it happened, during a congressional recess. So this, what became a controversial nomination, was in fact a recess appointment. And so when Washington nominated Rutledge, he was making an appointment that inflamed many of his opponents. Why was that? Rutledge had been a member of the Second Continental Congress from South Carolina. He had been an outspoken member of the Constitutional Convention, primarily because he was a strong advocate of slavery. And so while many considered his views obnoxious, he nevertheless hailed from an important state and a very important region. And George Washington was intent on creating some geographical representation on the Supreme Court. So he sent the name of Rutledge to the Senate while Rutledge was serving essentially a recess appointment. But when the Senate returned, what was the Senate Judiciary Committee was pretty solidly opposed to him and initially rejected the nomination. Ultimately, the Senate itself was so concerned about Rutledge because of his purported mental illness and his tendency to abuse alcohol and a somewhat obnoxious character that he served only a very short time. And in fact, such was his instability that when he returned to Charleston, he threw himself into the Charleston harbor in an attempt to drown himself. And very ironically, 2 slaves passing by happened to see him flailing in the water and saved his life, which brought to an ironic end his long career, colored by the advocacy for slavery. And so he was a controversial Supreme Court justice, only serving a short time, and his name is long forgotten. The next controversial Supreme Court nominee would have been Roger B. Tawny, who was nominated by President Jackson. Now, Tawny was a person who alienated many members of the Senate. He had very strong views. He was essentially as stubborn as Andrew Jackson was. When Andrew Jackson sent the name of Tawny to the Senate to serve on the Supreme Court, the Senate, in fact, rejected him. Undeterred, this very stubborn Andrew Jackson sent his name up yet again, and he was rejected. The reality is that on 3 occasions, President Jackson nominated Roger B. Tawny to some important posts, including to serve as Treasury Secretary when the Senate rejected him. Finally, after 3 tries, Tawny was successfully approved by the Senate, went on to become Chief Justice, and of course, the name of Chief Justice Roger B. Tawny will always live in infamy in American constitutional history, precisely because it was Tawny who wrote the opinion for the court in the Dred Scott decision, when he wrote unnecessarily and in terms that inflamed the public that both slave and free African Americans could never achieve citizenship. And that contributed to the outbreak of the Civil War. So Tawny is a name whose record is mixed at best. Following the controversial nomination of Roger B. Tawny, the next controversy probably involves Justice Lamar, who was appointed in 1888. Justice Lamar thus became the first Southern justice to serve on the court since the outbreak of the Civil War. He was a strong advocate for Southern rights. During the antebellum period, he was an active secessionist and a defender of slavery. But he also was a person who, at the end of the Civil War, sought reconciliation with the North, sought accommodation. And so in many ways, some of his earlier misdeeds and positions that were so decried by Northerners were overlooked as members of Congress, and particularly the Senate, realized that it was important for the nation to move forward. And so Lamar was approved, but there were bitter memories by some senators, and so he survived only by a close vote. Those nominations that I've just reviewed probably are not well known by followers of American constitutional history or the history of the Supreme Court. But this next one that I'm going to mention will be somewhat familiar to you. And this is the appointment by President Woodrow Wilson in 1916 of Louis Brandeis. Brandeis, by the way, who has been heralded by scholars, historians, court watchers as one of the truly great justices, almost didn't make it. Louis Brandeis was the first Jewish citizen ever nominated to the Supreme Court, and he was known as the people's lawyer. Justice Brandeis would become a great justice, as I've said, and his legal career from the start showed tremendous promise. When he attended law school at Harvard, he achieved what was then and still is the greatest academic record in the history of that distinguished law school. In the second year of school at the Harvard Law School, his eyesight was failing. And the best doctors in Boston and New York told him that in order to save his eyesight, he would need to avoid reading for about a year. Now, that would be very strong medicine for a second-year law student because, as you all know, law students do a lot of reading. And the very thought to Brandeis that he would have to remove himself from law school, to withdraw, was too painful to accept. And so he was determined to stay in law school, and he talked friends into reading the voluminous materials to him, the cases, the law notes, the law review articles, statutes, and the like. And they complied, they helped him, and even though he was unable to read those documents with his own eyes, he nevertheless continued to remain the #1 student in his class. Pretty remarkable, I think you'll agree. When he graduated from law school, he and a classmate named Samuel Warren opened a small practice in the Boston, Cambridge area, and they quickly attracted a lot of powerful corporate clients because they were brilliant, especially Louis Brandeis. And it didn't take long before Brandeis, in the 1890s, became known as the nation's most outstanding attorney. And reflective of his ability, he also became a very, very wealthy attorney. After he amassed a small fortune, Brandeis decided that he would no longer defend American corporations, that instead he would follow his heart. And he began then to defend the small fry in America, men and women and little-known causes, and he was very successful, indeed winning case after case against powerful corporate interests and others with tremendous pocketbooks. And so he began slowly to earn the enmity of American corporations and the business world. When he earned this nickname, the People's Lawyer, it was richly earned because he took a new tack in examining the impact of the law and appealing to state and federal courts alike by introducing what became known as the Brandeis Brief. Here was an attorney who began to examine the socioeconomic impact of statutes and governmental practices, urging the court to embrace the socioeconomic impact on the lives of Americans in reaching their decisions. As I say, this was a novel approach, far different than the somewhat programmatic or machine-like theories which said justices and jurists alike should simply take a look at the facts and apply the law, and out would come a mechanical decision during the period known as mechanical jurisprudence. At any rate, Brandeis then became well known for the Brandeis Brief, full of dozens and dozens of pages, replete with references to sociological research, political science, economic research, and it was a very new, very different approach to the interpretation of statutes and the Constitution. President Woodrow Wilson became a huge fan of this progressive attorney, and so he decided to nominate him to the Supreme Court in 1916. Brandeis had a huge following, but he also had great opposition. Remember, he's Jewish, and there was a broad streak of anti-Semitism in America at that time. And so anti-Semites campaigned against Brandeis. The corporate world named him enemy number one and campaigned very hard against him. The former president, William Howard Taft, campaigned against him. A number of presidents of the American Bar Association campaigned against him. And so it was a titanic battle that was waged for more than 4 months before Brandeis was finally confirmed to the Supreme Court. And indeed, in many ways, the Brandeis nomination remains the most controversial in our history. He went on to distinguish himself for the next 15 years, and as I say, ranks on the list of all scholars' great jurists. Back to Brandeis in a moment. When we think about controversial Supreme Court nominations, we're wise to remember one of the great historical efforts renewed in the news here recently to quote-unquote pack the court. And this is exactly what President Franklin D. Roosevelt had in mind in 1937 when he sought to obtain legislative approval of a measure that he and his administration introduced, which would effectively increase the size of the Supreme Court from 9 to 15 jurists, essentially an increase of 6 jurists. And as it happens, the motivation for FDR's aim to increase the size of the court and thus to pack it was the fact that for years, ever since he had assumed office, the Supreme Court had been striking down New Deal legislation, which he and his team had cobbled together to try to lift the country out of the Depression. And he was hobbled in this effort by the notorious Four Horsemen of the Supreme Court, known in those days as crusty old conservatives who were wedded to another vision and version of the American Constitution. And so there's a great battle waged between FDR and the New Deal and his many followers, and the Four Horsemen on the Supreme Court who were able to cobble together a slim majority of 5 justices and defeat many of the programs and policies that had been presented by the New Deal team. In 1936, FDR made the Supreme Court a primary campaign issue. He campaigned against the Supreme Court for what he considered its outdated interpretations of the Constitution, labeling the justices as practitioners of horse and buggy jurisprudence. And FDR, as you know, won a huge battle, won a huge victory in the 1936 presidential election, winning more than 60% of the popular vote. And with that great victory, he thought Americans were supportive of his campaign against the Supreme Court's old-fashioned jurisprudence. That emboldened him in the early months of 1937 to introduce what became known as the court packing plan. This became notorious. Even though he commanded a huge majority in both the House and the Senate, many of whom considered themselves to be New Deal members of the House and the Senate, he found himself denied at every turn. The Senate Judiciary Committee could not bring itself to support FDR's plan, and the full Senate could not support itself. Indeed, there was a great outpouring across the country by people who thought that the president was tinkering with a sacrosanct institution, namely the Supreme Court. That's how the court was viewed by many in America in 1937. I'm not so sure Americans have the same view of the Supreme Court today. At any rate, FDR's plan to pack the court with progressive jurists who would undoubtedly be reflective of his mindset, or at least he hoped, to overturn the rulings rendered by the conservative justices and thus uphold New Deal programs, was thwarted. However, the intense pressure brought upon the Supreme Court won a big victory, because a conservative justice Owen Roberts, no relation to our current Chief Justice John Roberts, switched his vote and decided to start voting with the progressives to uphold the 14th Amendment in a way to, in a particular case in 1937, to uphold the state of Washington's minimum wage law, and that represented a turning point. And so, as scholars and pundits quipped, a switch in time saves 9. With Roberts' conversion to the progressive side and the decision to begin to uphold FDR's New Deal programs and progressive legislation across the country, the Supreme Court now was firmly supportive of the FDR presidency. That court packing plan, of course, was not lost on Americans, and as you know, there has been considerable talk in the past several weeks of whether or not the Democrats might seek to bring balance back to the Supreme Court, which has been in the hands of conservatives for many years, by increasing the number of seats on the Supreme Court. Of course, who knows at this point, but let's say this, that in fact there's nothing illegal or nothing unconstitutional about increasing the size of the Supreme Court. Indeed, from the founding up until 1864, the size of the Supreme Court changed 6 times until in 1869, the number 9 seemed to be an appropriate number, and that's where we've been ever since. But in fact, if Joe Biden and Democrats should succeed in winning a majority in the House, the Senate, as well as the presidency, there would be nothing in the Constitution that would stop Democrats from doing so. And let's understand from a realistic perspective, for all those accusations or assertions that in fact the Democrats might pack the court, let's understand this is exactly what President Trump and Senate Leader Mitch McConnell have been doing from the time that Donald Trump reached the Oval Office. From the very time, of course, that President Obama still had 11 months to go in his presidency and nominated Merrick Garland, the Chief Judge of the D.C. Court of Appeals, to fill the recently vacated seat on the Supreme Court because of the death of Justice Scalia. Mitch McConnell, the Senate leader, announced at that point in February that he would not hold any nomination hearings for any nominee brought to the Senate by Barack Obama, thus denying President Obama and his nominee a constitutional hearing through the Senate. That marked an effort then, ladies and gentlemen, to pack the court, to deny a sitting president with 11 months to go in his last year, in his second term, the opportunity to nominate and appoint somebody to the Supreme Court. Thus, there is background to the concerns about conservatives trying to pack the court. So let's stay tuned. We'll address this question at a later time in this series on constitutional conversations. After the failed effort by FDR to pack the court in 1937, there were a couple of more controversial nominations to the court that we want to take account of tonight. Many of you may remember that in 1967, when a vacancy occurred, that President Lyndon Johnson decided to appoint the first African American to the Supreme Court. And that was, of course, Thurgood Marshall, one of the greatest, if not the greatest, civil rights attorney in American history, and in fact, the attorney who successfully argued the case of Brown versus the Board of Education to the Supreme Court in 1954, when he was able to persuade the court in a unanimous ruling that segregation in public schools violates the Equal Protection Clause of the 14th Amendment. Lyndon Johnson, who had been an outspoken advocate of equal rights for Americans, decided to bring this nomination to the United States Senate, but he did meet considerable opposition. And the final vote, while overwhelmingly approving Thurgood Marshall, There were about 11 people in the Senate voting against him, but 20 abstaining. A record number of abstentions is explained largely because Lyndon Johnson had succeeded in pushing through Congress in his own strong-armed way the Civil Rights Act of 1964, the Voting Rights Act of 1965, and as many of you may remember, Lyndon Johnson knew that those tremendous victories fought in the great cause of equal protection, fighting the war on poverty, and promoting equal rights for African Americans came at a huge price. He knew, as he told aides, that he just lost the South. Hence, in 1967, Southern Democrats, many of whom had been very, very supportive of LBJ, could not forgive him for the way in which he had ramrodded through the Civil Rights Act and the Voting Rights Act of 1965. And even though some would not vote against Marshall, they nevertheless abstained. Thurgood Marshall goes to the court then in 1967 with more than a little controversy surrounding his nomination. It was in 1968 and 69 that we see more controversy. President Johnson in 1968, following the retirement of Chief Justice Earl Warren, decided that he would promote to the Chief Justiceship his old friend and supporter Abe Fortas, then serving as an Associate Justice on the Supreme Court. Fortas was a very popular liberal, a person recognized by many in the country as one of the nation's foremost attorneys, often, in fact, arguing famous pro bono cases in front of the Supreme Court, including the landmark case Gideon versus Wainwright. At any rate, Johnson calculated that he could push his old friend through the nomination process and make him the next Chief Justice, but he overestimated his waning strength because the same group that rose in opposition, Republicans and conservative Democrats from the South, in opposing the Thurgood Marshall nomination a year before, now gathered more strength and successfully prevented Johnson's efforts to promote Fortas to the Chief Justiceship. And in fact, during the middle of the hearings, Fortas withdrew his own name, returned to his position as Associate Justice. Unfortunately for Fortas, his name became engrossed in some controversy that arose out of concern that he had received inappropriate support for some lectures and some other activities while he was on the Supreme Court. He resigned from the Supreme Court. Richard Nixon comes into the presidency. He now has a golden opportunity to replace a couple of justices. And he began to fill a spot on the Supreme Court, a seat on the Supreme Court, by nominating a federal judge named Haynesworth from Florida. The Senate, however, was not interested in approving this nomination. And in fact, he was defeated 55-45. What was the reason for alarm? It was precisely because Haynesworth was on record as supporting some white supremacy causes. Well, folks, during the height of the civil rights movement in America, nominating an advocate or a supporter of white supremacy to any degree was the death knell. He was defeated. Richard Nixon was angry, decided that he would then nominate a man named Carswell, and Carswell had nothing in his career that distinguished him or suggested he would become a distinguished Supreme Court justice. But Nixon decided that he would fight like hell to put Carswell on the court, as he himself said. Well, the problem with Carswell, as I say, is that there was nothing to distinguish him. One of his supporters, in fact, during the floor fight for Carswell, was left in a moment of resignation to say, quote, "So what if Carswell is not the stuff of Holmes and Brandeis? So what if he's only mediocre? Mediocre types in America deserve representation on the Supreme Court as well." And he was defeated. So you see the weak position that Nixon and Carswell found themselves in. Ladies and gentlemen, if the best thing you can say about your nominee is that he's mediocre, you know the nomination's in trouble. It was at that point then that Nixon moved on to Lewis Powell, who was able to fly through the confirmation hearings. After that point, we can move forward to what in many ways constituted one of the greatest confirmation hearings, shrouded in controversy, and that was the Robert Bork hearing in 1987. Bork was nominated by Ronald Reagan for his advocacy for a very conservative approach to constitutional interpretation. He was an advocate of originalism, and Bork was heralded by many people. He had had a very distinguished career as a professor at the Yale Law School. He had served as a judge on the D.C. Court of Appeals, and people thought that even though he had very controversial views, that his many speeches, his many articles, his books, his scholarly reputation would be enough to overcome the very conservative nature of his views. The fact is, however, the United States Senate had just been controlled in the last election by the Democrats, and they were determined to stop Robert Bork. And so Bork was defeated. He was defeated in large part because of a public relations campaign against Bork run by Senate Democrats, but also many private groups who felt that his opposition to Roe versus Wade, his belief that Griswold versus Connecticut, a 1965 landmark ruling by the court holding the right to privacy, was wrongly determined. His belief that Brown versus the Board of Education was wrongly defeated. The combination of his opposition to the right to privacy and to the greatest civil rights case in American history, the Brown case, was more than the Senate could tolerate. He was defeated. He returned to the D.C. Circuit Court of Appeals, but stayed only a year and then decided he wanted to become an advocate for certain public policies. After Bork was defeated, which was a pretty considerable defeat for the cause of conservatism, President Reagan decided to nominate Douglas Ginsburg, a Harvard law professor who seemed not to grate on anybody in a particular way, but nevertheless controversy surrounded his hearing as well. Here's why. In the course of the hearings, it was revealed that Professor Ginsburg often joined his law students at Harvard to smoke marijuana. And once that was revealed, he lost support of the moral majority, the conservatives, and Ginsburg was forced to withdraw. You might say, pardon me, that his nomination went up in smoke. After that, you could turn to the 1991, forgive me, it was a very bad pun. In 1991, the Clarence Thomas nomination by President George H.W. Bush became very controversial because you'll recall Clarence Thomas, who had headed the Equal Employment Opportunity Commission and had been a senior official in the Department of Education, had been accused by one of his former employees at both agencies of sexual harassment. This would be Anita Hill, Professor Anita Hill. And thus the fact that Clarence Thomas, an African American, would be replacing an iconic liberal jurist, Thurgood Marshall, and the fact that his record was not in any way comparable to Thurgood Marshall's roused liberals to the cause to oppose him. Moreover, the controversy involving accusations of sexual harassment meant that this nomination was going to be very, very controversial. In the end, of course, the Senate decided to have not one, but two judiciary hearings, and then he was approved by a very, very narrow margin, the closest in American history, by a count of 52 to 48. controversy continued to follow Justice Thomas as he continued his career on the Supreme Court. If we move forward, we understand the great controversy that surrounded the hearings of Judge Kavanaugh, who was in fact approved by the Senate. He, like Thomas before him and Neil Gorsuch before him, in one way or another, considered himself a textualist or an originalist in his approach to constitutional interpretation, which is essentially the philosophical approach embraced by Judge Barrett. And so here we are, we return to the nomination hearing that will begin next week for Judge Amy Coney Barrett. As I said earlier, she styles herself an originalist. You can imagine that there will be some important questions posed to her during her confirmation hearings. She will be asked, for example, is your originalism selective? What does your philosophy say by way of guidance when it comes to the interpretation of the Constitution? Her approach, she said, is Justice Scalia's approach. What was Scalia's approach? It was, simply put, a particular version of originalism which relied on the interpretation of the constitutional text. If the text did not provide a power or a right, then from Justice Scalia's perspective, the power or the right did not exist. If that is in fact Judge Barrett's perspective, then we would ask her, if we were there to pose questions, we would say, now, Judge Barrett, you've written in one or two important law review articles that a sitting Supreme Court justice is not bound by the precedents set by earlier courts unless those precedents are what you call deeply ingrained in the institutions of American government. And you have cited two cases in particular that enjoyed that status. One is Marbury versus Madison of 1803, the famous case in which the court for the first time introduced and exercised judicial review. The second would be Brown versus the Board of Education, which you have said is so deeply ingrained in our institutions that it cannot be repealed. That's 1954. We wonder what constitutes that status, the sturdiness of Marbury and Brown. After all, Marbury versus Madison, in which the court introduced judicial review, does not rest on a textual interpretation of the Constitution, because indeed Article 3 of the Constitution, the judiciary article, is silent on the existence of judicial review. So if it's deeply ingrained, what constitutes that solid foundation that you find so convincing? Or consider that many conservatives, including Judge Bork, who was aligned with Justice Scalia, consider that Brown versus the Board of Education rested on shaky grounds. Why shaky grounds? Because critics of Brown, including subsequent scholars, thought that the 14th Amendment Equal Protection Clause was not envisioned by the framers of the 14th Amendment to bar segregation, and thus the ruling in Brown would constitute an activist decision. So we would wonder, if Judge Barrett finds that decision so deeply ingrained, what provides that sturdiness? And we ask those questions because she has said that, in fact, she does not consider Roe versus Wade, the 1973 decision in which the court upheld as a fundamental right a woman's right to an abortion, as being anything of a fundamental nature. And certainly not, she said, not a super duper precedent, and thus subjected to repeal. And indeed, in 2006, then law professor Amy Barrett, a professor at Notre Dame, signed an advertisement that called for the repeal of Roe versus Wade, using the language that abortion is barbaric and that it needs to be repealed. So you see, one of the great questions surrounding the nomination of Judge Barrett is she willing to follow her own views that abortion is barbaric, and that she would use her position as a sitting member on the Supreme Court to overturn Roe versus Wade, thus denying women autonomy over their reproductive organs, thus denying women the right to choose. And so if in fact her originalism suggests to her that Roe versus Wade is not a fundamental right, not in fact a guarantee of a right that cannot be overturned, then we wonder, what is the fate of Roe versus Wade? And this makes millions of Americans, particularly women, very anxious about the future of reproductive freedom. There are many questions that could be posed to Judge Barrett, and I'm sure that the confirmation hearings, which will be televised, will be fascinating to observe. But before we reach that conclusion, we ask, given the fact that a number of members on the Senate Judiciary Committee have been stricken by COVID-19, will they even be able to participate? Will there be enough members to constitute a quorum? Will the Senate Judiciary Committee even be able to conduct business? And then, once, if and when the Senate does approve the nomination, then what would a floor fight look like? Will there be enough Republican senators stricken by COVID that they cannot join the fight? Remember, the tiny margin of control enjoyed by the Republicans means that if 3 or 4 are unable to participate for some reason, then in fact the hearings may not be successful, at least as envisioned by Trump and McConnell. So we have a number of questions before us. I see that there are questions being addressed to me now, and I'm very happy about that. So I guess, Taylor, we should take a moment now and turn to some questions. Thank you very much. I always enjoy the questions. And by the way, as we proceed to these questions, let me share with you that the Alturas Institute will hold a virtual Conversations with Exceptional program next Friday, October 16. You may have seen the initial ads. Many of you will be receiving emails over the next couple of days. You'll see other advertisements. I hope you'll consider joining us. That's October 16 from 9 to 3 p.m. Mountain Time. Admission fee is $20 for the 6-hour program, featuring some of America's most remarkable women, touching on some of the pressing problems confronting America today, from race relations to the question of the importance of a peaceful transition to power in a democracy, to the status of women and their pursuit of gender equality, and one that I know you'll be particularly interested in, and that is the question of election security and Russian interference in the 2020 election, in addition to some other intriguing sessions wrapped around the theme this year of America Reimagined, which gives our remarkable women the opportunity to stretch a little bit, to take stock of where America stands and where it might be headed if we were to change some policies and programs. So please tune to our website for more information about our program on October 16. So thank you, Taylor. We got some good questions, it looks like.
Yeah, it looks like it. And we're super excited for that October 16th event. So go to our website and buy tickets. So let's get to some questions. I see one just popped in here from Jolene. She asks, any predictions on this judicial appointment and therefore Roe v. Wade?
Well, I love that question. That's, I think, the question of the moment. Millions of Americans want to know that. Unless COVID-19 interferes to prevent Republican senators from being able to participate in the hearings, there's very little that Democrats can do to stop the nomination of Judge Barrett from going forward. And presumably, if she is appointed, then the questions involving Roe versus Wade that would come before her would raise very important questions about her own judicial ethics. Here I'm talking about the question, should she recuse herself from cases involving abortion rights. Why? Because remember, in that 2006 newspaper ad, she did in fact indicate that abortion is barbaric and that Roe versus Wade should be overturned. What's the relevance of that to her potential recusal? It's that the federal law governing recusal, which does not, while it does not apply strictly to Supreme Court justices, but all other federal judges, but nonetheless should be a guiding light for Supreme Court justices, says that federal jurists should recuse themselves in any case in which they have either tentatively or directly or even indirectly indicated where they stand on an issue that comes before them. And certainly there's no question now that given the fact that Judge Barrett has indicated her own personal and political view, which is opposed to abortion, by all rights she should recuse herself. And then that would raise the question of whether or not there is a majority to uphold Roe versus Wade or not. So I'm sorry I can't give a more definitive answer to this good question, but I think it hinges on the uncertainty of COVID. It hinges on the uncertainty of whether Judge Barrett would recuse herself and the very future of the number of Supreme Court seats in months and years ahead.
Thank you so much for that question, Jolene. We've got a lot more rolling in here.
Great.
Patrick has just asked, in your opinion, Dave, would an overwhelming victory by Democrats this fall provide sufficient political cover for Democrats to increase the size of the court?
That's a great question. I think so. As a matter of fact, it's a great question from Patrick because an overwhelming victory, which would lead the Democrats to retain control of the House, regain control of the Senate, and enjoy the control of the White House, I think would represent a national mandate supportive of the policy proposals of Joe Biden and the Democrats. And it would be an easy argument to make that Donald Trump and Mitch McConnell have been engaging in court packing, to pack the court with ultra-conservative jurists. And now all Democrats want to do is to redress that imbalance, restore some balance to the Supreme Court. And yes, I could see that the Democrats would have a powerful argument supported by public demand, frankly, for increasing the size of the court. And let's just say once again, the Constitution leaves to Congress the authority to determine how large the Supreme Court should be. And historically, we've seen the size of the court wax and wane. There would be nothing constitutionally that would prohibit Congress from doing that. Glad to have that question.
Yeah, thank you. Leslie wants to know, what is the process to add justices to the Supreme Court?
That's a great question. The reality is that Congress would simply pass a law to enlarge the size of the Supreme Court. So we would have the bill introduced in the House and the Senate. Presumably a majority of Democrats then would support the bill, pass it, and then it would go to President Joe Biden's desk and he would sign it into law. At least that's the way that the hypothetical could work out. And so maybe we will see that. Maybe we won't. There's no reason for candidate Joe Biden to take a position on this issue, even though, of course, in the first presidential debate and in last night's vice presidential debate, both Trump and Pence tried to force presidential nominee Biden and vice presidential nominee Kamala Harris to address that question. They don't have to. And the fact that they refused seemed to anger some conservative supporters, but at the same time, last night, for example, in the debate, Vice President Pence was unwilling to address the question of would he use his position to encourage President Trump to step down if in fact he loses the election. And he also didn't answer the question posed to him by the moderator, Susan Page, on what they would do to protect Americans' right to coverage for pre-existing conditions if and when they are successful in winning at the Supreme Court, when in fact the Supreme Court hears that very case challenging the ACA on November 10th. And by the way, it raises once more the issue of recusal for Judge Amy Barrett. Everybody knows, as President Trump has said publicly many times, he wants a Supreme Court with a full complement of 9 justices, not 8, which is where it currently is, given the loss of Justice Ginsburg. And he wants a full complement of 9 justices to address the question of the constitutionality of the ACA. It thus becomes very clear that President Trump is nominating Judge Barrett to the court with the expectation of a favor. It seems to me the worst thing that Judge Barrett could do is to sit on that case because she would be forever remembered as a justice who either repaid a favor or, in essence, chose to anger the president that nominated her. I think, given the presidential expectations and the tremendous controversy, she would do well to recuse herself from that case.
Interesting. Thank you so much for that question. Virginia is wondering, and this is kind of similar to a previous question, but she's wondering, is it wise to add more justices to the court?
That's an excellent question for contemporary purposes as well as historical purposes. There's no magic number in the number 9. It's just where we've been since 1869. But the arguments for enlarging the court are strong and compelling, given the fact that we're in a period in which the Republicans have added many dozens of young conservative jurists to the federal courts, essentially packing the federal courts with jurists who in many ways have not exhibited the credentials or qualifications worthy of a federal judgeship. And now this effort to appoint Judge Barrett in a way to pack the court with ultra-conservative jurists. So the Democrats essentially would be simply trying to redress the imbalance that has occurred precisely because of the Republicans' plan to pack the court.
Jimbo says, "Thanks, Dr. Adler. I never learn more than when I listen to you."
Oh,
that's nice.
Love that. Love that comment. Thank you.
Let's wrap up with one more question. Colleen asks, have some justices changed their ideology over time?
That is such a wonderful and question and reflective of knowledge. I love that question because a number of Supreme Court justices have seemed to change their view on some of the most important issues of our time during their years on the court. Let me give some examples. So Chief Justice Earl Warren, who of course wrote the unanimous opinion in the landmark case of Brown versus the Board of Education in 1954, striking down segregation in public schools, came to the court as a rock-ribbed conservative, exhibiting no particular interest in equal protection or African American rights. But after he arrived at the court and he had many discussions with his colleagues and others, he began to change his views. And so he certainly shocked President Eisenhower, who had nominated him to the court with the full expectation that he would behave like the conservative Republican Attorney General from California that he was. And when, in fact, Warren wrote that opinion in Brown, the president, a very popular Dwight D. Eisenhower, expressed his outrage. He held a press conference and denounced both Earl Warren and another justice, William Brennan, who had been a Republican who began to change his views as, quote, the worst damn mistake I ever made. So there was the expectations dashed, I should say, for the popular president. It was Earl Warren who in 1969 in his memoir called Super Chief, who expressed that no man can sit on the Supreme Court for any period of time without changing his view of the world, the Constitution, and the role of the Supreme Court. Harry Blackman, who was appointed by Richard Nixon, was another stalwart conservative, but began to change his views over the course of his very long career, nearly 30 years on the court. And in fact, and it was Blackman who wrote Roe versus Wade. And at the end of his career, as he started winding up his time on the Supreme Court, he was interviewed by a reporter who said, Mr. Justice Blackman, it appears to everybody that you've changed your views, that you've moved from the right to the left. Blackman quipped, I didn't move from the right to the left, the court moved to the right. Of course, he did change his views. There are many other jurists who changed their views over the course of their history on the court, and it raises a question of why. I think it's largely a function of the fact that when a man or a woman reaches the Supreme Court, they realize that their responsibilities have grown tremendously. They are now responsible for promoting the mantra on the Supreme Court building, equal justice for all. And so it would be a rare person who could view that powerful seat and loaded with responsibilities with anything but a broad responsibility to promote equal protection under the law. And I think that's what helps to explain why some jurists move, frankly, from the right to the left. We've only seen one Supreme Court justice move appreciably from the left to the right, and that was Byron White, who was a Kennedy nominee, Byron White. But everybody else seems to have moved from the right to the left, and that move has, of course, disappointed many. Certainly when Ronald Reagan appointed Sandra Day O'Connor to the Supreme Court in 1981 as America's first female jurist, there was every expectation that she would vote with the conservative line to overturn Roe versus Wade, something she was never willing to do. And in fact, she wrote some very brilliant opinions in which she strengthened Roe versus Wade and limited the ability of states to regulate the performance of an abortion. That's a primary example of a strong, very independent jurist who is one of a kind, and I had the good fortune to have had many conversations with Justice O'Connor, a thoroughly admirable Supreme Court justice and independent woman. So there have been a number of examples. Reagan was disappointed then with O'Connor, and she received scorching blasts from Justice Scalia, who said in a dissenting opinion, you cannot take her seriously. Of course, Scalia was willing to torch anybody who disagreed with him. Other presidents have been disappointed by the performance of their nominees. Just to cite a couple more examples, you could go all the way back to 1902 when President Theodore Roosevelt nominated Oliver Wendell Holmes to the Supreme Court. By that point, Holmes was already a living legend. He had been a distinguished jurist on the Massachusetts High Court. He had written a classic on the common law. He had been a decorated soldier in the Civil War, and in fact knew Abraham Lincoln, had come from one of America's leading families. In every way, he was an aristocrat. At any rate, when he wrote a few opinions early in his time on the court, it angered Teddy Roosevelt, and Teddy Roosevelt denounced Holmes at a press conference and said, quote, I could carve out of a banana a judge with more backbone than Holmes has exhibited. I think that shows strong language in 1902. Yeah. It seems humorous to us today. But to wrap up our time, because you're indicating to me that our time has expired, let me finish with a story about Justice Holmes. He left the court when he was 90 years old, still very able to do the job mentally, but feared he was slowing down, and so he decided to leave the court. And it was befitting his great national iconic status that upon his retirement, the news networks turned over their microphones to him for an hour to say to Justice Holmes, hold forth to America. Tell us anything you wish us to understand. That's quite a stature, right? Well, Holmes was a tremendous person. In his last days on the court, he engaged in his daily constitutional. He would take a walk around Washington, D.C., and he so loved the beautiful flowers that bloomed in the spring. And Washington, of course, we all know is a beautiful place in springtime. On one of these last walks, he's talking with his clerk who accompanied him on the walk, and he looks across the street and he spies an attractive woman. And he says, "Oh, to be 75 again." I think that puts age in perspective.
It really does.
Thank you.
Thank you, Dave, so much for your knowledge on this topic. We really appreciate it. And thank you all so much for your questions and comments. Again, we appreciate your participation. Thank you for everybody who has donated and participated in all of these weekly videos. We could not do it without you guys. With that, I think we'll wrap up. Any other comments?
I think just a reminder to people to tune into our website so that they can register for Conversations with Exceptional Women on October 16. And we'll be sure to send email notes and reminders to you. Thanks for joining us, and thank you, Taylor, for moderating this program.
Absolutely. If you're looking for tickets to our event on October 16th, go to our website at alturisinstitute.com, and we will also be posting updates on Facebook, Instagram, and Twitter, so please follow us on social media. Hey, pup. Thank you all for tuning in. Have a good night.